I'm a professor at John Jay College. I'm so delighted that so many of you are up this bright and early. This is the breakfast, the monthly breakfast for dispute resolvers that's co-sponsored by the Association for Conflict Resolution of Greater New York and the City University of New York Dispute Resolution Center at John Jay College. This is our 235th breakfast since 9/11. We're now in our 20th year, just about, come September. And this is our 12th virtual breakfast. We always met in person until last April. Last April was our first virtual breakfast. So in many ways, today is an anniversary. Last March was the last time that we met in person. And for those of you who were there, little did we know what we were going to experience, right? You may recall that we made signs about thinking about how to meet and greet creatively, and don't hug or shake hands, do elbow touches and toe touches. And, the 6-foot distancing really wasn't quite part of our world back then. It seems it was almost fun to try to figure out how to meet and greet. There wasn't the fear of being near anyone.
You're muted, Maria.
Sorry, that was me by mistake. Admitting someone from the waiting room. Maria, you're muted.
Maria, you can unmute yourself, and the last thing we heard was our adventures in elbow touching greetings.
Okay, I guess I don't realize when I'm being muted, Chuck. So my name is close to the top. When we admit people, it's easy to mute me. So that
your name got jumped in. Yep.
Yeah. Okay, so it was fun. Little did we know what we were going to experience over the next year. Since April, these breakfasts have been recorded, and all of the recordings at the present time are on the ACR-GNY website, and that's www.acr-gny.org. You can see the breakfasts since last April there. We can't do these breakfasts every month without this wonderful team that I'm a part of. Julie Denny, Chuck Newman, Matthew Latimer, and Nikki Borofsky. It takes a village every month to make sure that this all happens. And we are really fortunate to have such a dedicated group of individuals who also serve as co-hosts. So there are 5 of us every month who have our fingers on the button to make sure that everyone is admitted, but also that our environment is safe. And and we hear about Zoom bombing, etc., we are all ready to take action.
You're muted again, Maria.
I'm sorry. While clicking, Maria's name goes out. Now. Sorry.
So we are all ready to make sure that our environment is a safe one, that if we are Zoom bombed, that we will either mute or remove the person from our space. We are really committed to having as respectful a space here as we can ensure everyone. This morning, we're really delighted to have Lisa Pomrantz with us, a very timely topic for us, particularly in light of some of the discussion on the listserv over the last 24 hours or so. And I'm going to turn it over to Julie Denny, who will do the more formal introduction of Lisa. Lisa, thank you for being with us.
Oh, I'm really delighted.
Thank you.
Thank you, Maria. And yeah, happy anniversary, people, I guess. Lisa Renee Pomrantz, who's on the screen there, is a graduate of Harvard University and Boston University Law School. She clerked for a federal judge. She practiced litigation and then worked for 15 years as a senior level in-house counsel for NEC. Currently, she's practicing business and employment law while mediating and arbitrating commercial, consumer, and employment disputes for AAA, and also she serves on the mediation panel and the ADR Advisory Council for the U.S. District Court for the Eastern District of New York. She's held a variety of leadership roles with the ACR, the New York State NYC-DR Dispute Resolution Association, and the Suffolk County Bar Association. She's an old friend of ours and a popular speaker at many legal and business meetings and conferences. She's published an email newsletter called Making the Connection, which I'm sure many of you have seen. She's contributed numerous articles to various legal and ADR publications and provided online and live training for business and legal audiences. She's taught at Touro Law School, where she's teaching employment practices now online. Also New York Law School, the university, I love these, Lisa. The University of Tartu in Estonia and Vilnius University in Lithuania. And she's received a whole bunch of awards for her professional activities. We're delighted that you're here. Lisa, take it away.
Okay, is it time for me to share the screen?
Sure.
Yeah. Let's see.
There we go.
There we go. I go through this. You would not realize that I do this every week in class, and every week it is an adventure. I am on. I have the IT instructional person at Touro on speed dial, and I say that I'm the worst techno-klutz that there is. So anyway, Julie, thank you so much for that lovely introduction. It's really wonderful to see all of you there. I do want to say that University of Tartu and Vilnius University, I taught in person through an organization called the Center for International Legal Studies, and I look forward to resuming those adventures as soon as I can. They're really, and I don't know if we have any attendees. I do stay in contact with colleagues and students from those experiences. And I do fear that if we go all virtual, we're just not going to make the same kinds of connections. So, Maria, I had the same thought yesterday about, you know, that we could not have asked for a better prequel to my presentation. This is a topic that is near and dear to me, the advantages of transparency in mediation. I do want to say that I come to it.
Oh, you're muted.
You're muted, you're muted.
Lisa, you got muted. This time it wasn't.
I just unmuted. Are we good?
Okay.
Yeah, my name must be next to Maria's, or somebody switched it with Maria's. In any event, I come to this topic from a variety of perspectives because I have represented parties in mediation. So I'm, to some extent, a consumer of mediation services. And I mediate under a variety of rules. AAA has its own rules. The Eastern District has its own rules. I also do workplace mediation for MWI, and they have their own procedures. And I also teach interviewing, negotiating, and counseling. So part of what I'm doing is teaching students how to represent parties in mediation. So I've thought about this topic from a variety of perspectives. And I'm very glad that I'm following fairly closely the presentation that you had from Alex Carter, who wrote the book, Ask for More, because in her book, which I kind of think should be called Ask for More from Negotiations, maybe, she does emphasize the importance of being transparent both with yourself and with the other party in terms of really getting the best possible result for the parties in mediation. So this topic sort of came to mind because over the years I've heard about the magic of mediation, and I found that term kind of off-putting, because as a potential consumer and as a provider of services, I want to understand what it is that I'm getting, and I want my clients and customers and the users of my services to understand what they would be getting from me. And the traditional view of mediation is also that the parties control the outcome, but the mediator controls the process. And which, by the way, for those of you who do both mediation and arbitration, is actually the converse of arbitration, where the parties control the process and the arbitrator controls the outcome. But I believe that the parties can and should have input into what the process is. They should be able to make knowledgeable decisions about the process that they're selecting. And I also think that if the mediator is more transparent with the parties and their counsel, that they will encourage the parties to be more transparent with each other and with the mediator. And that transparency about the process can help build trust and rapport, promote more effective participation by the parties and counsel in the process, and that this is especially so because participants, and I include both parties and their counsel, often are not familiar with the process or with a variety of approaches to mediation that are available. And they may, in fact, lack negotiation skills and not be especially competent at participating in mediation without the benefit of some mediator input on that issue. So with any luck, I'm going to be able to page down. That would be nice. Why can I not page down? That is interesting. There, did somebody else do it or it eventually gave in? Okay. So what I'd like to discuss today are what are the opportunities for greater transparency in different types of mediation? What might be the potential advantages of greater transparency? And what are the appropriate limits of transparency? So I'm going to try to, I don't know why I'm having trouble paging down. Is one of you controlling?
No.
Let's see.
Try using the arrow in the lower left.
I am. Apparently, if I click, it happens. If I click my mouse, so I'll click the mouse. So to me, there's much to be said about transparency in the mediator selection process. I myself have had instances where, as counsel for parties, I and opposing counsel have actually agreed on what approach to mediation we feel that the parties want and need, and have shared that with the mediator and not gotten what we asked for. So again, I think that leads to dissatisfaction and not the kind of process that's most helpful to the parties. So I think transparency in the mediator selection process helps organizations and parties select the most suitable mediator for the parties and for the nature of the dispute. And some of the disclosures that mediators can make that can assist the parties in a more educated decision regarding their neutral is what training has the mediator had, what credentials do they have? Do they come from a legal background, an accounting background, a CDRC background? Are they an accountant? What are they? What experience have they had, both in terms of mediation and other processes or experiences that might be of assistance or useful in the mediation process? I always say to everybody that my mediation experience started when I was in-house counsel at NEC, working with a variety of executives who didn't get along with each other and had competing incentives and goals. So sometimes experience like that can be especially helpful in particular kinds of mediation. And we've heard about different approaches to mediation, and some mediators are consistent in taking what they believe is the appropriate approach in all mediations they conduct. And other mediators, like myself, tend to be more flexible, and our approach is to use what we think is appropriate in the specific circumstance. Sometimes I can be facilitative. Sometimes if the situation requires it or I feel it's appropriate, I can be evaluative. But I think it's important for the mediators to be transparent with the parties as to the approach that they are intending to use, approach or approaches. Other issues that I think that the mediator should be very transparent about are fees and billing arrangements. Do you charge for prep time or not? Do you have cancellation fees? What are there supervision arrangements in place? And of course, the approach that the mediator is going to take often varies based on the rules that are applicable. And therefore, I always try to be very familiar with the applicable rules, whether it's AAA, Eastern District, or when I mediate workplace issues for MWI, I follow their procedures. And with any luck, if I click, we will, what do you know? So now I want to talk about promoting transparency in the intake process. And I mean transparency, openness between the parties and the mediator and between the parties themselves. So in that initial call, I try to help the parties and their representatives prepare for a more constructive process. And so I do think, as an experienced mediator, and I also have been acted as settlement counsel for parties in resolving numerous disputes. I think that the exchange of information and views ahead of time is very important. So in that initial call, that will be something I will discuss, and I will say to the parties or their counsel, as applicable, what documents or information do you need to feel prepared for this mediation? And I also think, as I was going through my notes last night, that it's not only helping the parties and their representatives prepare for a more constructive process, but the more sharing of information that can and views that can happen in advance, at least from my perspective, it allows me to prepare better. So these are the types of, this is the type of information that I try to get either through interviews or pre-mediation submissions. I try to understand the factual background, the nature of the party's claims, if it's a legal dispute, what are the key documents, and I ask for copies of them, history of settlement discussions, perceived obstacles to resolution. What is it that they feel is getting in the way? Do they have any ideas for resolution that maybe they've been fearful of broaching? Now, it's interesting, under the Eastern District rules, the parties are required to prepare and submit pre-mediation submissions to the mediator, but they're confidential. Under the AAA rules, the default rule is that they are to be shared. So the approach that I take, in keeping with my, what I view as a transparent approach, is that I do encourage the parties to share their written submissions, but I tell them if there is something they don't feel comfortable sharing, they can have a confidential supplement to what is shared, or they can have a private conversation with me in advance of the mediation. I do have a sense of what I think it takes on the part of the parties and the parties' representatives to make the most of mediation. And one is also often mediating with parties and sometimes with counsel who've never been in a mediation before. And so I do share my views about what might be helpful. And one thing that I think is a requirement for constructive mediation is that the person attending on behalf of the parties, of each party, be both knowledgeable and have authority to make decisions. There's nothing worse than being in a mediation, trying to work out a resolution and finding out that the president of the company who is there actually has no authority and must go back to the board of directors. So that's the kind of thing that I would, I'm sorry, did somebody say something? Oh, okay. That's something I'd like to know in advance. If the matter involves an insurance company, I try to explain how important it is to have the claims representative participate. I try to explain that hearing about what's happening in the mediation is not the same as being there. I share with the parties some guides that I think can be helpful to either them individually or if I'm speaking with counsel. I recommend to them to help the parties prepare. Specifically, both the American Bar Association and AAA have various guides to mediation. which I think are helpful and have sort of questions in them that the parties can work through in advance of the mediation. And I do encourage counsel to work through those questions with the parties. And one of the reasons I do that is counsel is unlikely to admit to me that they don't know how to participate in a mediation. So if I ask them to work through these guides and questionnaires with their clients, they're more likely to be prepared. That probably is I'm going to get to later limits on transparency. I do not tell them I'm telling you this because you may not know what you're doing. But in any event, I do believe that preparation is very important by everybody, including the mediator. And so I do share with them my views about what is the most productive. I share suggestions about productive ways to prepare. I also encourage them to shift their focuses from their clients' positions to interests. I would say I get mixed results with this, but part of the reason that I ask for perceived obstacles to resolution and potential approaches to resolution is to try to get that shift happening. I also discuss with them openly whether they want to do opening statements. And if they do, I sometimes share suggestions about what might be a helpful opening statement, something along the lines of saying to the other side, I know we have our differences today, but I'm so glad that you've agreed to attend this mediation to see if we can work things out. And I try to explain to them that an opening statement, like you would hear in arbitration or litigation, where one party recounts everything bad that the other side did, is not likely to make the other side very receptive to anything that you have to say. And it sort of gets people stuck in focusing on their positions. So let us move on. That was not good. There we go. So I also try to promote transparency in the mediator opening. Again, I think it helps build rapport and helps the parties understand and participate more constructively in the mediation process. I think also to some extent helps alleviate their anxiety about the process. And I will describe the process and what the role of the mediator is and the approach that I'm taking. Well, this could vary depending on what context I'm mediating in. For example, I've done workplace mediations where you have, let's say, conflict within a team and also conflict between that team and other teams, and where I might say, okay, I know that there's conflict between your team and the other team, but because you have internal conflict within your team, I think that we need to start small here first and see whether we can get all of you on the same page in terms of how your dealings with each other, and also help you as a team think about how to resolve your conflict with the other team. So I will share with them what I see as the approach that I'm taking, and how I see my role. I'm big on excuse me, sports and music analogies and language. So I try to explain to people that, you know, sometimes when people come to mediation, they think of it as, you know, like one football team playing against another. But really what it is that we should all think of ourselves as being on one team solving a common problem. I urge the parties in their use of language and in their focus to try to focus on the problem and not the people involved. I emphasize to the parties the benefits of achieving their own solution, and I often give examples to illustrate how this might be the case. For example, in a shareholder dispute, I may say to them, you know, if this goes to arbitration or litigation, you know, the court or an arbitrator is very limited in terms of the remedies that they can award. There are solutions you all might be able to agree to on your own that you never could achieve if it's adjudicated. And I give some examples. I said, sometimes one party will buy the other out. Sometimes the parties will decide together that they want to sell the business. Sometimes businesses are actually capable of being split up. Sometimes people decide, you know what, I don't really like being a business owner. I'd like to sell out, but continue to work in the business as an employee or a consultant. I said, one of the advantages of mediation is the parties get a chance to explore all these different alternatives. So another thing that I share with the parties is I actually discuss with them that there are naturally occurring potential barriers to resolution. And I call them the twin evils of confirmation bias and reactive devaluation. And I explain to them what they are and how they get in the way of people accurately hearing and being able to assess what the other party is saying. And I do that for a couple of reasons. Is that I think that it helps the parties recognize that behavior in themselves maybe and to adjust for it. And also that if the other side is displaying that kind of behavior, that maybe they won't take it personally, that they'll understand that this is a natural reaction to conflict. And I should mention, by the way, that when I discuss the process, I do share with them that I meet with the parties in joint session and sometimes in caucus. And I say a few things about that as well. I mean, I happen to be a mediator that overall prefers joint session. And I tell them that there are many advantages to joint session, that I like to try as a mediator to come to an understanding of the situation, and that I think it's helpful to the parties to also come to an understanding of the situation. And it's almost like putting a jigsaw puzzle together. And if we're all in the same room asking questions and sharing information and views, then often we can come to a common understanding of the situation, which is helpful to resolution. Whereas if the parties are only in caucus, then we're not all hearing the same thing at the same time. And I have to try to share those puzzle pieces back and forth and get permission to do so. And so as a result, I tell them, I quote from, I don't know whether any of you were fans of the English beat in the 1980s, but one of my favorite lines from the song I Confess is, "It's cards on the table time." So I encourage them to put their cards on the table, because that's the only way that potential resolutions can be identified and evaluated. I do encourage them to come to the process with an open mind and an open heart. And I explain to them that generosity begets generosity, that it's human nature, that if one side is generous, makes a concession that's meaningful, acknowledges your interests, your concerns, that the other side will reciprocate. And I point out that the opposite is also true, that parties who are mean-spirited and nasty tend to get the same, it tends to engender the same behavior on the part of the other party. So, these are the things that it's almost, we've heard about sort of coaching in the caucus, but this is almost like sort of a coaching in the joint session, in the opening session, I think. So I also try to be as transparent as I can about the ground rules. I encourage attentive listening. We know it as active listening. I tell people, turn off those cell phones, put them away. And I think on all of these ground rules, I have to say I'm a human being. I don't always follow all of these myself, but I really try to walk the walk. So attentive listening, no interruptions. I encourage them to try to communicate in ways that they can be heard and understood by the other party. So to think about how what they're saying will be heard by the other parties. This is a controversial thing, but the evidence seems to be that venting can be counterproductive in mediation for a variety of reasons. This topic actually came up in a webinar I attended earlier this week. When people vent, they get angry. Angry people don't make good decisions. Venting also disrupts communication, because the person being vented at is going to be less receptive to what the person who's venting is trying to communicate. And it also re-traumatizes the person. And I was thinking about a mediation I did recently where one party said something to the other party that offended them, and it wasn't intended to offend. And it was very unfortunate. One thing I'm really struggling with these days is I find that counsel for the parties are really opposed to joint sessions, or some are. And I am deferential to the parties as far as the process, but sometimes I think that I really need to say, I really can we please try it? But in any event, in that case, the person who said the thing that was offensive, really said, I understand why she took it that way. I didn't mean it that way. I could never get the parties in joint session. The case did settle, but when I tried to convey that sort of apology and explanation from one party to the other through caucusing, the party was I know in theory that the party should be more willing to hear things when it comes from the mediator than from the other side, but I think in this case, it would have been more effective to hear it from the party themselves. And when I tried to explain this, the party kept saying, oh, he's a liar. He meant that. He, and just was not receptive. So this is something I'm struggling with when we get to the Q&A afterwards. If anybody has any thoughts about how to persuade counsel of the benefits of joint session or to give it a try, I certainly am open to that. So in any event, I do address the issue of venting. Something else I do try to address is I often find counsel, oh, please, I'm sorry. Sorry. I do encourage counsel to allow me to communicate with the parties and to allow the parties to communicate with themselves and to allow the parties to speak for themselves. I mean, when I used to be like around a table with the parties and counsel, I actually like to have the parties in between me and counsel because I think it, sort of disarms that, protective shield that counsel likes to put up. I also, I will, when necessary, provide legal information or do reality testing and provide evaluative input if the case requires it. For example, I mediate FLSA cases in the Eastern District. Often the conflict has arisen because the employer didn't know the applicable rule. And it may be that their attorney doesn't know it either. So you might have a situation where an employee who was not exempt voluntarily came to work early or worked through lunch, and the employer is saying, I shouldn't have to pay them because I didn't ask them to work then. And the legal rule is that employers have to pay employees for all time worked unless the employer has told them not to work during that period. So, I will, when the occasion calls for it, provide that kind of information. But what I do, which is different from what I hear about other mediators doing, is I tell them, to the extent I'm providing information or being evaluative, I am going to say the same thing, whether I'm in joint session or caucus with one party or the other party. I've heard that, mediators will meet with one side, say, you have a weak argument on this point. And then they go in with the other side and say, you have a weak argument on this point. I don't do that. If the rule is you have to pay the employee for all time worked, well, I'm going to say that, regardless of the setting in which the issue comes up. And I do think that this transparency preserves the mediator's credibility and allows for smoother transition between caucusing and joint sessions. As far as the ground rules, I am respectful of the role of counsel. I tell the parties that they may meet, they can ask whenever they want to consult with counsel. They can take breaks. They can request going into caucus if there's something they don't feel comfortable discussing in joint session. I'm doing okay about time. Okay. So I also try to use a transparent approach in joint sessions. Sometimes actually in workplace mediations, there are things that information that I can share that's helpful to the parties in understanding their situation. I don't know how many of you have heard about the workplace drama triangle, where A has a problem with B, but they don't address it with B, they address it with C. Then that results in conflict between B and C, and then C tells D about it, and the whole issue spreads. So, you know, that's a way of explaining that it's best when conflicts are addressed directly with the party that you're having it with. Or, for example, if conflict might arise because of cultural differences, I may explain, and I worked for a Japanese company as in-house counsel for 15 years, and I, you know, did see that firsthand. And I can explain that different cultures, some are more individualistic, some make decisions, you know, on a collective basis. Different cultures have different attitudes about the importance of timeliness, or some have more indirect communication, some have more direct communication. And so that, you know, the way that, you know, that there might be differences in styles of communication or decision-making, you know, that are just a function of what people have learned, and that they're not anything to be taken personally. And we should try to understand the differences and see if we can come up with a common way of working together that will, you know, work for everybody. I do, in joint session, I do try to obtain information to fill in the gaps, to try to achieve that common understanding of the situation. It's, again, I sort of feel like it's filling in the pieces of the jigsaw puzzle. You know, if you only have a couple of pieces, they can fit together in multiple ways, but the more pieces you fill in, you know, there's really only one way it kind of, you know, they fit together. I try to identify common understandings and interests as they appear. I emphasize to them, and that could be something like, well, if it's a medical setting, I'm hearing that all of you are really committed to excellent patient care. You know, but I'm hearing that you have some different ideas about what the barriers are, or the procedural aspects, but I am hearing you're all, you know, committed to that goal. Or if it's in the educational setting, I hear that you're all really committed to educating the students and maintaining a respectful culture within the school. And then I point out that identifying those common interests leads to the ability to ask the right question. And I feel that the joint session, especially if the people are going to be working together in the future, is a way of sort of getting on the right track and working together, and sort of practicing how you're going to relate going forward. So, for example, if it's a medical situation and they have common interests about, you know, patient care, but differences about how to accomplish it, I might say, well, you know, I hear you're very concerned about patient care, and that there's a concern that the night shift is not getting the right information from the day shift, or something like that. So let's discuss, what do you think would be the best way to facilitate that exchange of information? And so that is a way that I try to ask the right question, to emphasize, to kind of build on their identification of their common understandings and interests, and show them how they can relate to each other going forward. I do try to brainstorm with them, although there's some evidence that brainstorming is not a good idea. I mean, hopefully by preparation, they've thought through things in advance, but that if you merely rely on brainstorming and people are just suggesting off the cuff solutions, that they're often not very well thought out. So I do think that the mediator can have a role in reality testing potential approaches. I think it's important to document points of agreement as reached. So you all feel that it would be a good idea for this team to meet every week and review the following points. Okay, so, and I will read to them what I'm proposing to write down and say, have I captured it correctly? One other thing I say about caucuses in the opening is I said, please don't draw any inferences from how long I spend in caucus with one party or the other, because often the parties think if I'm spending more time with one party that I'm somehow favoring them. So I tell them that sometimes people draw that inference, but I encourage them not to. I said it could be that one side is more reluctant or resistant to hearing the other side's perspective. That might be why I'm there. So please don't draw any inferences. I will explain, I will discuss and explain the transitions between joint sessions and caucus. If we're in joint sessions and I've asked a question, it seems to make everybody feel uncomfortable and not very forthcoming, I might say, we seem to be at the point that it might be helpful for me to meet separately with each side to explore this issue further. If we are in caucus and I maybe have brainstormed, I have to come up with a better idea, better name for that. But for example, I really love exploring creative solutions. I handled a trademark infringement case, or mediated one recently where, again, one party didn't realize what they were doing was infringing the other side's trademark. And they had a good business relationship before that. And this party was willing to acknowledge that they shouldn't have done what they did do, and were willing to implement certain protections to make sure it didn't happen again. And so when they came up with this proposal in caucus, I said to them, well, I think it would be great for the other side to hear that proposal from you. Shall we meet in joint session to have that happen? And it definitely is my preference that such a proposal come from the party who's going to be carrying it out. And I also revisit the guidelines for the process as needed. Sometimes, you have heated discussions, especially with counsel, they interrupt each other, and I'll go back and say, as a reminder, we've agreed not to interrupt each other. Or if somebody is venting, I try not to criticize them for venting, but I will try to redirect them and say, I hear you're upset about that, but I think we've agreed to try to focus on solving this issue. Can we do that? So let us move on to promoting transparency in caucus. I usually will not ask the parties to reflect on how the process is going in joint session. So if I am in caucus, I will, ask them, how do you think things are going? And if they have contributed constructive ideas or expressed themselves in a way that was very helpful, I will often take the opportunity to say, you know, the idea that you suggested to do X, Y, and Z, I think that really helped move discussions forward. Or, you know, when you explained what you meant by that remark that the other party took as offensive, I think it helped, you know, address that concern. I will, again, you know, communication and mediation, you know, and in joint session where the parties are in each other's presence and may be feeling stressed because of that, you know, I do try to make sure that the party has understood what the other party has said, you know, and also if they haven't acknowledged the legitimacy of the other party's interests, I might say, well, from what I'm hearing from the other side, it's important to them not to appear that, not to have it appear to the staff that you're publicly undermining them. Can you understand their concern about that? And so from what I'm hearing, they would prefer that if you have criticisms, you express that in private. Is that something that you think you could agree to? So, you know, those kinds of issues maybe have to be addressed, you know, better in caucus. Sometimes I'm concerned that a party might be holding back on something that's important to them. So I will try to use that opportunity to probe, you know, is there something you hope to achieve from this, or some interest that or concern that you have that we're not addressing? I do try to, when I meet separately, if there's information that there's or views that they're telling me in caucus, I do encourage them to disclose it. And again, my preference is that they disclose it themselves, but I do at the end of every caucus, I say, could you identify for me what you have told me in caucus that remains confidential? And also in caucus, when we are discussing proposals, I may discuss with the parties, what would be, how could that be proposed or expressed in a way that the other side would receive it in the best way. I've had instances where you get into this shuttle diplomacy where one party is trying to dictate to you as the mediator how you convey a proposal or offer. And sometimes they want to do it in a way that I find sort of either manipulative or not respectful. And so I may honestly discuss with them, I'm prepared to convey that offer, but phrasing it this way, I have some concerns that it might engender this response. Would you feel comfortable if I expressed it this way instead? So what are the limits of transparency? Well, I think when one is dealing with dishonest, disengaged, sabotaging, or instructionist parties or their representatives, it is not helpful to confront or accuse them of that behavior. I must say I try to work around them in a variety of ways. There are times, especially if it's counsel, that I will try to get permission to have the parties meet with me without them. But I must say that I don't, when somebody, and I certainly will do reality testing. I mean, I will use techniques, but I'm generally not going to, I think I tried to tread lightly. Again, when somebody is venting, in the case I have in mind, I did not say to the person, see, you're getting yourself entirely worked up and you're not even hearing what the other side said. You know, so I won't, you know, I try to acknowledge her feelings and, you know, redirect the discussion. Mediating in toxic workplaces is an interesting thing, because sometimes I think management thinks mediation is a substitute for leadership. So sometimes you're mediating between lower level people and you are exploring, for example, the use of profanity or people yelling at each other, and they report, well, that's how the supervisors talk to each other. So, you know, I've been brought in by the organization. I am not going to express my views about how management is behaving. But in that situation, I'll just say, well, you know, let's just focus on what it is that you all can control, you know, in your own team and your own work relationships. I mean, I may, in debriefing to management, and again, I tend to be honest with the clients, say that, well, it was reported to me that the behavior that you've observed and asked me to help address in mediation, I hear that it's also present in other parts of the organization. I may suggest some kind of training on respect in the workplace, but I'm not going to undermine management or the organization to employees. With ill-prepared, self-interested, or obstructionist counsel, again, I'm not going to address that. I will try to go back and say, well, you know, the Eastern District rules require that you commit to a mediation of X number of hours, and that you know, people are obligated to mediate in good faith, and this is what's involved. So could we just please stay and try to do that? But I really, I guess the limits of transparency have to do with addressing what I see as bad behavior, and that addressing it in a transparent fashion. You know, I think that there are limits that apply in those circumstances. So I think I've now reached Q&A with about half hour left. Should I stop sharing the screen so I can see other people?
Absolutely. I think that would be great.
Yeah, well, there's always hope. I think I did it, correct?
Yes, there you are.
There I am. Okay, so my understanding, I guess, Nikki, I hear you're a champion chat.
There have been there have been a bunch of great questions and comments in the chat. Kind of we'll go on a bit of a historical listing, and also everybody should feel free to raise your hand virtually, and we'll kind of queue you up if you'd prefer to ask a live question as well. And Chuck, Julie, and Maria, please feel free to jump in. There was an early question from Cheryl asking about how you handle venting in Caucus.
Okay. By the way, I did want to mention something that if anybody wants to subscribe to my newsletter, they could just send me an email or something and I'll put you on the list. Venting in caucus. Well, I try to have been sort of transparent about the issue up front. And I also want to be clear that I don't handle divorces, divorce mediation. But again, what I try to do is acknowledge that the person is upset. I don't label it as venting because I don't want to be critical of somebody who's upset. That is unlikely to be helpful. So I try to acknowledge that I hear that you're upset, but for example, but might it not be possible that this gentleman did not mean, he's saying he understands why you took it this way, but is it not possible that it wasn't intended that way? So I try to redirect it as opposed to, naming it as venting. I hope I've answered the question.
I think so. And Chuck kind of followed up the question with a comment of, it is also important to what you mean by venting. And I think, you've spoken about how as a mediator, you help to direct and reflect that process towards productive ends. We have a next question, and Kishore, if I get this wrong.
Oh, actually,
go ahead.
I just wanted to follow up on my question. What I was asking was with respect to venting that I've sometimes found in caucus that parties, just to kind of get to the next step, I mean, it's kind of a balancing act in that sometimes, they just want to make sure that someone has heard what they had to say before they can kind of get to the next step. But again, if you let them go on too long, then they're kind of, entrenched in their position. So it's kind of a balancing act. And I just wanted thoughts about that.
Well, first of all, Cheryl, how delightful to see you.
Yep, likewise.
And I do understand what you're saying, so I'm not going to cut them off at the path. You know what I'm saying? Mm-hmm. But I am trying to be mindful of both what I've read as far as the science and also what I have seen, which is, when somebody really goes off on a tantrum, it really isn't helpful. They've worked themselves up into quite a state. So again, other than hearing them out a little bit and say, I hear this must have been a very upsetting situation for you. But also sometimes the venting can be used almost strategically as a block against hearing what the other side, is trying to say. So but I have to say, if it's going to happen, better in caucus than in joint session where,
Okay. Yep. Thanks.
Anyway, good to see you.
Yep. Likewise.
And William Sparks wanted to follow up with an additional comment on venting. Are you there, William? Can you unmute yourself briefly?
Okay. Yeah. Lisa.
Yes.
So great to see you, Lisa. And listen, as I heard you speak about venting, let me just be a bit of a devil's advocate, if I may.
Shocking. Go ahead.
I know. So listen, my experience some of the time is that venting is in fact critical to resolving a case. And what I mean by that is, don't be afraid. Don't be afraid of venting, particularly between parties. My experience has been that if you can get the parties in a room to express true emotion, anger is nothing to be afraid of. And just let me finish. if you can, in particular cases, if you're able to discern, as I know you are, what is really behind the issue, there is nothing wrong with allowing those two parties to express themselves honestly. If you set the ground rules, you can actually get behind it and allow the process to work out. Nothing wrong with honest emotion.
Well, I appreciate your views on this and look forward to having lunch and pursuing this further. I would say it depends on how it's expressed. And I also think, you know, that different mediators develop their own style. And that's okay. I mean, there may be mediators who make more productive use of anger than I'm able to. But I think if we as mediators are honest with the parties about our approach, you know, then they can find the mediator whose approach is, you know, works best for them. But again, I do think there's some downside about venting, and there also is concern about decision making when people are angry. And again, I like to try to have it's not my style. I feel in some ways we all have our comparative advantages, that mine is helping the parties be creative and explore different options. And I guess for what I feel I'm best at, it's not helpful. But we can take this conversation offline and explore it further. I'm interested to hear more about how you use how you feel venting can be helpful.
All right, I'm gonna close the faucet on venting for a moment, but put a pin in it, because there's clearly a lot of interest, including Brad Roth, who mentioned using I statements to model, and Robin, who agreed. But I want to pivot to a question from Julie Margolis, who asked about attorneys who are very resistant to sharing any information that they perceive might be damaging to their case, even in caucuses. How, after, you know, saying all that you've said and encouraging transparency and noting the important reasons, what can you do as the mediator?
Well, I'm pleasant but persistent. So, and I often, as I said, I try and join session to say, you know, I think it's important to me and to everybody here to try to understand the situation. And also, you know, both so that everybody can evaluate their cases, and also so that we can identify potential, you know, ways that it could be resolved. And I start with the, you know, the idea of transparency and disclosure, like from the very beginning. And I'm sure that that value is also reflected, like in, like I know on the AAA, you know, resume, where you have to discuss your approach to mediation. So, and I just keep quoting from the English speech. What can I say?
Thank you. I think that kind of dovetails nicely into a question from Donald, who asked, you mentioned that you help counsel prepare for a mediation. What do you tell them about preparation? And is that, you know, are these some of the issues that you cover?
Well, I also have a presentation on neutralizing the litigator mentality in mediation, which when I was at some other session, I mentioned I had, and a lot of people asked for that PowerPoint. But, you know, I share with them, you know, my views about how they can be most helpful to the process for the benefit of their clients. And I really try to set the tone for, working together in a collaborative way, from the very first call. And one thing I do when I see counsel being cooperative with each other, I'll call it out and say, that was really helpful to learn that. And I also appreciate how well you're, working together in, sharing information. So I definitely give positive affirmations for that. And I also, if somebody is playing it very close to the vest, I do try to explain about how, you're not sharing information that, it can impede the process and get in the way of reestablishing trust, and also obstruct resolution, because the other party doesn't know what they don't know. And so if you want to move the process forward, I really think it would be helpful for you to, disclose and answer these questions.
Excellent. And we've got some nice props for you from Michael Cassandra for appreciating your transparency about turning anger into productive use. And a bunch of people have asked if your slides that you used today will be available, and if
Sure. I mean, I think you guys have them, right? I sent them to you in advance.
Yep,
so
we will.
You can post them or share them or whatever, of course.
Excellent. We will be sure to circulate those along with a link to the recording that should be up next week. I wanted to turn the mic over to Felicitas Court now. You can unmute yourself and ask your question live.
Thank you very much, Nikki. That was a wonderful presentation, Lisa.
Oh, thank you.
Yes, I am approaching this subject from the clinical, as a clinical psychologist. And when you mention, I'm going back to venting because it's very important. One of the emotions that have been very recently analyzed or studied is the emotion of anger. So I would suggest not to go into the nitty-gritty of clinical psychology, but a general psychoeducation, what anger means in general, like a non-specific, but just in general, what anger is. Actually, I'm sure Maria recalls I presented a little while ago about Violence Prevention Project, which had very friendly to use information on how to deal with anger. And you cannot put anger under a rug, and you cannot put many people that are angry in the same room, because you're gonna get, it's what the way to find out of your group how many people are angry is by a simple questionnaire, simple 5-10 questions that can let you know where you're at, and then you can separate the people that are really angry, that you have to deal separately. And the ones that are so, maybe they need to be assertive and learn how to communicate with your fantastic transparency techniques, or, but then who is in front of you and how you can deal with that. And there are many, I can go into this, but there are many simple ways to learn how to tolerate anger, and how to be assertive, and also above all, relaxation. The people, mindfulness, and stay calm and know how to deal with the situation. And they're all from the behavioral and cognitive therapies. My information.
Well, I'd love to see your presentation, but I have to tell you something. I think I'm aware that I don't want to deal with a lot of anger as a mediator. Okay, I think I'm aware of that. And so I don't do divorce mediations. I don't do custody mediations. I tend to do like more complicated business and employment kinds of situations. And so I think I'm aware of, being transparent with myself and potential parties. I think I know kind of what my sweet spot is. And I try to only take, actually, that extends to clients too, I have to tell you. that I only take well-adjusted clients because it's just, I'm not saying that I don't recognize the need for dealing with people's emotions, but probably dealing with extreme emotions is not my forte. So I think I, know my limitations and try to work within them, honestly.
Thank you. I wanted
But
to.
but I would love to see your slide. But again, the kinds of disputes that I'm having, I'm mediating or even acting as settlement counsel, tend not to involve those really extreme emotions. But I've had some clients like that.
And I encourage everybody to share in the chat the resources that they think will be pertinent and helpful, because this just helps to build our community and our resources, and it will all be memorialized through the website. I usually download the chat as well, so you can kind of have these as go-tos along with the slides. Mark, I'm going to read, Mark Kleiman, I'm going to read your question and invite you to clarify and or expand afterwards. But Mark says a bit of a provocative statement. Would you suggest failure to further process? Wouldn't transparency dictate the framing of some of these negative tendencies while together in proactive, more positive ways? He understands the desire, but it gets close to direction. Is this a dilemma?
I think I'm understanding Mark's question, and Mark is one of those people that I've had great chance encounters at conferences with, and I know we probably come to the subject of mediation from a different perspective. And again, I think as long as one is transparent about one's approach as a mediator, which I definitely try to be, and if somebody is behaving in a way that is, I see as counterproductive or, blowing things up, I will reflect on it. I do respect the party's ability to resolve the conflict in what's the situation that's best for them. But I didn't really address this, but I also am a believer in the value of subject matter expertise on the part of mediators in terms of helping to identify potential resolutions, that they might not have thought of. And in the commercial world, one of the issues I see is that litigators are not transactional lawyers. So actually they haven't thought of these, and I fundamentally am a transactional lawyer and not a litigator. And so I can be useful in suggesting things that neither the parties nor their counsel have suggested. So it might not be the approach that other people take. And again, I think there's multiple valid and viable approaches, but as long as we're honest with the parties about the approaches we take, hopefully, they're getting what they want and will think is appropriate for them in their dispute.
Great, thank you. Speaking of subject matter expertise, we have a question that digs a little bit more into workplace mediations. Elena asks, what do your confidentiality agreements provide about workplace mediation, and how much are you allowed to report back?
Well, that's an interesting question. So the workplace mediation I do is on behalf of MWI, which is a firm in Boston. So I follow their it's not my agreement, it's their agreement, their procedures. And I often actually debrief like intake sessions with the case manager there about to make sure that they're comfortable with what I propose to disclose. So I will share, general observations like there was a lot of feedback that the overall, that the behavior that they're, exhibiting towards each other is consistent with the behavior in other, departments, or the concern seems to be that there is conflict between this department and another department. So, but I try not to, I don't attribute specific observations or concerns to a specific person, and I really do try to handle it in a way that MWI is comfortable with, because I feel I'm doing it on their behalf.
Excellent. And again, Elisa's provided her her website and her newsletter, which is always great. I know I'm a subscriber and a fan, and it's color coordinated with your jacket today, which I love.
Of course.
I notice. We're kind of drawing to the close of the hour. I think Chuck has another question.
If I may, jumping all the way back to the very beginning of your presentation, Lisa, when you were talking about transparency in mediator selection.
Yes.
I think many of us are familiar that a lack of diversity in the ADR field is a serious concern. And I'm wondering if you see transparency in mediator selection as a way to help increase the diversity of people who become neutrals and the selection of diverse neutrals from the pool of all neutrals.
Well, that is a really interesting question. So I think,
well, not everybody agrees that diversity is a problem.
well, no, I think the issue, well, I've actually written about this. I kind of have thought, I know AAA has initiatives, and I've made some suggestions. I mean, one of them is taking people's name off the, the resume, so people are being picked on their merits. But, and also, and this sort of ties in with it. I know there's been a lot of talk about credentialing, and I did once post on the listserv that credentialing creates barriers to entry. And the Federal Trade Commission actually has this Economic Liberty Task Force that looks to ways to sort of reduce barriers to entry to different occupations. But I guess as far as disclosure, I guess I see disclosure as an alternative and a better alternative than credentialing. I'm not sure I answered that question.
Well, it's a tough question, and it's, it was, I'm going back to a sub point from the beginning of the talk, so, but thank you.
That's, anything else?
Any other questions? Somebody want to jump in live?
Lisa,
Yes.
Lisa, I'd like to ask a quick question. What do you do when outside counsel show up in bad faith at a mediation with no intention to reach a resolution, and that's only discovered during the course of the mediation? Have you ever encountered it, and what do you do?
All the time, and I actually have a presentation on that. But well, first of all, in the intake process, I try to remind everybody what their obligations are. And I try to, you know, I point out what the rules say about, you know, what the obligations of the parties and representatives are. And even if I can't resolve things, I actually have had instances where I've at least facilitated a conversation about exchange of information, you know, that might lead to settlement. And, but, you know, one can lead the horse to water. I wish in the Eastern District that you got to answer the question as to whether the parties participated in good faith or not. I believe when I was a mediator for the Storm Sandy mediation program with AAA, that was one of the questions. And I think that's an excellent thing in court annex programs to ask.
Okay.
Is there a way after this that can we save or send me the chat? Because I would love to, I can't multitask, so I haven't been looking at it.
Yeah, we will, as Nikki said just a short while ago, we do save the chat and we share that with everyone along with the video. And you said that you would make these slides available. So
yes,
we'll be sending out links to everything. On behalf of all of us, thank you so much for a wonderful morning. And it's now 10 o'clock. So we are officially adjourned, but Lisa, if you can hang around for a few more minutes informally for those who would like to chat informally.
Sure, be happy to.
We'd love to have you continue. And Nikki, you may want to turn off the recording so that we are now officially back on informal time here.
I will stop the recording. Thank you so much, Lisa, and thank you for everybody to share your morning with us. Thank you.